So having laid out forcefully last week, in very clear, strong language, Mr. Golding now is in a box of bricks. He laid out what he considered a principled position without being totally transparent with the people of Jamaica. It was not until he came under severe pressure that he buckled yesterday. He buckled under the pressure yesterday and admitted that he's still a British citizen. He didn't let on that at all. He issued a statement on Friday or Saturday it was. I'm a born Jamaican and have a Jamaican passport. I've never hidden the fact that my father, who came to Jamaica from the UK, had got me a British passport when I was a young child. From before first serving in government, I travel on my Jamaican passport when I go abroad. Like other Jamaicans, I apply for visas from countries such as the UK and the UK to go there. Well, if you have a British passport, you don't need to apply for a UK visa. So when did you give up your British passport?
Do you have a Jamaican passport, Mark Golding? And when you travel to the UK, do you use your UK citizenship or do you go and get a visa like the rest of us?
I travel on a Jamaican passport whenever I travel nowadays. Since I came into government in 2012, I decided I was not going to use the UK passport. In fact, I'm not intending to renew my UK passport. It expires this year.
Yes. Then he says, Jamaica is in the Commonwealth and our current constitution requires Commonwealth citizenship and at least 1 year's residence in Jamaica in order to be eligible to be a parliamentarian. Over the years, says Mark Golding, parliamentary candidates with Commonwealth passports have therefore legitimately participated in general elections to become MPs and sat in the Senate. On the other hand, the current constitution prohibits non-Commonwealth citizens who have pledged foreign allegiances from being parliamentarians. And this is a kick. The constitutional reform process should reconsider the current rule and make it accord with what he calls the realities of the Jamaican experience. His two members on the Constitutional Reform Committee, Senator Scott Motley and Anthony Hilton, MP, did not raise this there. The committee unanimously agreed that it was going to abandon this provision, which is a British colonial legacy. The same British colonial experience that Mr. Golding wants us to leave full-fledged behind, nothing more to do with it. And the question is, why? Now we know. Because if the new position of the Constitutional Reform Committee is adopted, then he could not continue to sit. Huh? Or he would have to renounce. So the question is, does he renounce or not?
Holding on to the privileges which come with being a British citizen. I am my father is what he said. He thinks it's unreasonable for people to ask him to give up something that the Constitution does not require him to do. I am my father. Now, isn't that interesting? It is, because you see, none of his family is from Jamaica. His family is from England, Ireland, Australia, Lithuania, That's where they are from. Except for those slave owners that had their, well, one of them had almost 50 slaves here. Benjamin Nunes and Esther Nunes. That's his great-grandmother, great-grandparents. His great-grandmother was Isabel Tyson, married to a fellow called Brown. Her great-grandparents were the slave owners. And he has no connection whatsoever to the island. He doesn't look like the majority of the people either. So the culture is different. The religion is different. He simply works here. Works here, but with very little ties. The home that they live in is owned by a company, Tajiba Limited. That's two initials of his 3 children. He said he transferred the shares of the company to the children sometime in 2021. That's what he said. And he's now a director with his wife in Tajiba Limited, which means he doesn't own the house, his children does. So there is a property that is in Portland that's in his wife and his name, land. Not quite sure if any building is on it by now. That was from 2015. And outside of that, he makes a declaration, a total declaration of 180,000 US in real property. But the Jamaican side, he declared $0. He did indeed, in his last statutory declaration, sold a property. I believe he said it was the one that was in Barbican, that was his matrimonial home, and he sold that. So he no longer has real estate properties, except for that one in Portland. And when you consider that this man is very, very wealthy, or this is what we believe at any rate, sometimes I have some doubts about that. To have real property of 25,000 US, that was what it was bought for. It's incredible. What does that mean? It means that his money is tied up in securities. Now I'm going to do an analysis, hopefully, if no excitement occurred. I'm well in advance of thinking it through on the statutory declaration of Andrew Holness, because I was looking at it recently and I noticed something. This is the first time I ever really looked at it, and I noticed something very, very interesting about the Prime Minister's declaration, and I won't say nothing more about that. I will let you know when I'm going to do that, and then upload the video, and then you'll be able to hear what I think about it. But anyway, so we are still on to Mark Goling's dual citizenship. He still sits in our parliament. I see the government engaging him. They can't do anything else. He's in the parliament. I don't see them making a move to have him removed, right? These are people who took an oath to protect the Constitution of Jamaica. This is why you don't pay these people any mind, you know. They're not sincere, you know. They're not sincere. They take an oath, they put up the Bible and put them hand on it, and they don't mean one thing. Although most of the government side did not swear on the Bible. Theirs was done by affirmation, you know. And they were well prepared to sit down and have this man who is illegal in our parliament. But I am sure it's only a matter of time before somebody step up and put it before the court and let the court decide whether or not, once and for all, whether or not Section 40 of the Jamaican Constitution says what Mark Golding thinks it says, and so many other persons thinks it says. Let somebody come forward and put it to the test. Let the court decide how that section is to be interpreted. All right, so let's leave that for now. So what am I going to talk to you about today? Well, let me first of all Welcome everyone for joining me. No, I didn't forget, and my mother grew me good, and I have manners. So hello everyone, this is Jamaica 411. How are you doing today? I hope I find you in very good health. I hope I find you very happy and looking forward to the future. I hope I find you all in a good mood, and I know you're anticipating what the Dickens Michelle is coming with this time. But let me complete my welcome. If you're joining me for the first time, welcome, welcome. I appreciate you. Please subscribe and share the video, because without the sharing, we can't get the message out. You won't be able to discuss with other persons what it is that I'm saying. When you're talking to them, they don't know who is that, who is this Jamaica 411, that sort of thing. So please share. If you like the video, please give me some encouragement and give me a thumbs up, as well as leave your comments. And I know you have some burning things to say, because we are Jamaicans and we have an opinion about everything. All right, so for my regular viewers, thank you so much for coming back and supporting the channel. You know, I do appreciate it, as well as your comments. And my subscribers, I have not forgotten you. I thank you so much. We're doing quite well, 7,000 and something. I think it's almost 7,800. I do appreciate you, as well as for all of you who, if you have not yet hit that notification bell, please do, because that is what will tell you whenever it is that I upload a video. So what am I going to be talking about today? All right, so I'm going to continue with the series on the dual citizenship and whether or not it's permitted in our parliament. What determines what the Constitution says is the judgment of our courts. So the politicians, the parliamentarians, they make the law, and the courts are charged with the responsibility of interpreting that law. And therefore, for us to understand what Section 39 and Section 40 means, we'll have to look now to what decisions were made elsewhere, because we don't have here a case where a Commonwealth dual citizenship was adjudicated in our courts. When the matter is finally brought, because I don't believe the 2 million voters will sit down and tolerate any dual citizen in Parliament. Right? It's just a matter of time. But when it comes to the court, the judges will be asked to look at cases where the courts made decisions about the Commonwealth dual citizenship and whether or not these Commonwealth citizens are permitted to sit in the Parliament as dual citizens. Now, Mark says he's legitimately in the Parliament. Others, including myself, says he's not. So we're going to now hear what the judges said in Sue versus Hill, and at the end of it you will know whether it's Mark that is correct or others that are correct. So let's listen. We're going to turn to a case which occurred in Australia. It is a dual citizenship case, Sue versus Hill. There are also cases in Guyana, and I do believe Grenada, where the courts ruled ineligible persons who had dual citizenship sitting in their parliaments from the Commonwealth. So it's likely that anybody that is going to take Mark to court will be using these or citing these cases as precedents for any arguments they're going to be put before the court in order to have Mark ruled as ineligible and the seat vacant. So you must be saying to yourself, Lada, what do Michelle, man? Where she get all them cases from? What the devil Australia and Guyana have to do with we? That dear judge can make decision over theirs and our judge go and pay them any mind. That can't be. Fortunately, it is, because all these countries operate similar law. It's known as a common law. And therefore, and even courts that are outside the common law, the judges can cite those cases. And what happens is that whenever you have a case, the judges have to spend a lot of time doing the research. So if another judge did the research and come up with all the arguments, with all the points, and remember, this is interpretation of the laws we're talking about. And so, they have all these precedences that the judges use. So yes, the persons, even in the Dabdo Vaz case, they were citing cases. I think it was the first time we were having those challenges. And they cited cases, all the cases were from abroad, and came up with a conclusion. So let me read now what it says here. In the United Kingdom is a foreign power. So there is some question in the society as to whether or not, you remember what section 40 said, that you're not eligible to be nominated for election or to be appointed to the Senate if by your own act you are under an acknowledgement of allegiance, adherence, or obedience to a foreign power or a foreign state. And there are some persons who are arguing that persons who are citizens of the United Kingdom cannot be said to be under an acknowledgement of allegiance to a foreign power. Their argument is that because the Queen is the Queen of Jamaica as well as the United Kingdom, that means that the United Kingdom is not a foreign power. So we're going to read here now what the Australian court said in their reasoning and what the status is in terms of the United Kingdom in relation to we here in Jamaica. Is it so indeed that the United Kingdom is a foreign power? Because if the United Kingdom is ruled a foreign power, in what circumstances is the United Kingdom a foreign power to Jamaica? And in that event, Mark Golding, having renewed his passport several times, can now be said by decisions of the court to be under an acknowledgement of allegiance to the UK. Okay? So let's see now what the Australian court said. On the 23rd of June 1999, the High Court of Australia handed down its decision in the case of Sue versus Hill. Now, the High Court in Australia is the highest court in Australia, and it is the equivalent of our Court of Appeal in Jamaica. So the Privy Council is above those two courts. It goes on to say a majority of the High Court made a declaration that One Nation Senator-elect Heather Hill was incapable of being chosen as a senator and therefore was not duly elected within the meaning of Section 361V of the Commonwealth Electoral Act 1918. Significantly, by doing so, the High Court ruled that the United Kingdom of Great Britain and Northern Ireland was a foreign power for the purposes of Section 44(1) of the Commonwealth Constitution. So we're going to repair to Section 44(1) to see what it says briefly. So we are going to begin with the qualifications of members. So the Australian Constitution says, until the Parliament otherwise provides, the qualifications of a member of the House of Representatives shall be as follows. He must be of the full age of 21 years and must be an elector entitled to vote at the election of members of the House of Representatives, or a person qualified to become such elector, and must have been for 3 years at the least a resident within the limits of the Commonwealth as existing at the time when he is chosen. He must be a subject of the Queen, either natural born or for at least 5 years naturalized under a law of the United Kingdom, or of a colony which has become or becomes a state, or of the Commonwealth, or of a state. So this basically is more elaborate than us. We simply say if you're a Commonwealth citizen, you're entitled to run for an election. If you're 21 and over, and if you've been living in Jamaica for 12 months before the election is called. That's what ours said. And they are saying the same thing. Commonwealth citizen, citizen of Britain, of any other state, whether they become independent or not, as long as they're a Commonwealth citizen, you can sit in their parliament too. So that's a qualification. Okay? So we now turn to section 44, which speaks now to the disqualification. And it is section 44.1 you heard mentioned before. So let's read. Any person who is under any acknowledgement of allegiance, obedience, or adherence to a foreign power, or is a subject or a citizen or entitled to the rights or privileges of a subject or a citizen of a foreign power. So once you're under an acknowledgement of allegiance, obedience, or adherence to the foreign power, or you're a citizen or a subject of that foreign power, or you're entitled to the rights and privileges of a citizen or a subject of that foreign power, you're not eligible to sit in the Australian Parliament. Ours went and added foreign state. Okay, that's a difference. What is also different about section 44.1 of the Australian Constitution is that it elaborated on the privileges as well as, so it's not only your allegiance, adherence, and obedience, but even if you are entitled to benefits and so on from that foreign state, you are ineligible. Okay. So let's turn now to the ruling of the court, or what was said to be the ruling of the court, the High Court in Australia. The majority came to this decision despite Australia's strong historical and emotional ties with the United Kingdom. According to the leading majority judgment of Gleeson C.J., Gomo, and Hien J.J., the expression a foreign power in section 44 does not invite attention to the quality of the relationship between Australia and the power to which the person is said to be under an acknowledgement of allegiance. In other words, our Constitution also said acknowledgement of allegiance to a foreign power. It never said excluding Commonwealth countries. It just says foreign power. So no foreign, any country that can be described as a foreign power is included in that, including the Commonwealth countries. So that is what they're saying here, right? Section 44 didn't say we exclude the United Kingdom. So let me continue. So they say now, the inquiry is not about whether Australia's relationships with that power are friendly or not, close or distant, or meet any other qualitative description. Rather, the words invite attention to questions of international and domestic sovereignty. In other words, when you talk about foreign power, what it really is about is what is a foreign power when it comes to Jamaica and the other rest of countries in the world. That's what that is saying. So here they are discussing the decision of the court and giving you a background to the case. So I want you to listen up carefully now and see if this case is similar at all to the situation that Mark Golding has found himself in. So what are the facts now about this case? It says, on the 3rd of October 1998, Mrs. Heather Hill, representing Pauline Hanson's One Nation Party, was elected as a senator for the state of Queensland. The Queensland governor certified the result on 26 October 1998. Following Mrs. Hill's election, businessman Henry Sue, a private citizen, lodged a petition with the Court of Disputed Returns in Queensland, requesting that her election be declared constitutionally invalid. Mr. Sue's petition submitted that at the time of being elected as a senator for the state of Queensland, Mrs. Hill was a citizen of a foreign power and therefore incapable of becoming a senator due to Section 44I of the Commonwealth Constitution, which is the Australian Constitution. That's what they call it. They went on to say Section 44 of the Constitution provides, in effect, that any person who has sworn allegiance to a foreign power or is a foreign citizen is not entitled to sit as a senator or as a member of the House of Representatives. Mrs. Hill was born in the United Kingdom in 1960 and emigrated to Australia with her parents in 1971 when she was 11. In January 1998, Mrs. Hill applied for and was granted Australian citizenship. You hear that? At the same year when she won the election, you know, she applied for her citizenship. At the time her Australian citizenship was granted, there was no requirement under the Australian Citizenship Act 1948 that a person's British citizenship be renounced. That is also true of the Jamaican Constitution. We do not require that anybody give up their citizenship to get our citizenship. Understand? So Mrs. Hill retained dual citizenship when her election to the Senate was certified in October 1998. It goes on to say, due to the High Court's decision in Sykes versus Cleary, number 2, it is necessary that a naturalized Australian with dual citizenship take all reasonable steps to renounce his or her foreign citizenship before the law of Australia treats that person as having renounced it. You hear that? Same thing with Jamaican law too. It was not until November 19, 1998, almost 1 month after her election was certified. Uno call Matthew there for me, my darlings. Please call Matthew Samuda and tell him to come and pay attention. Need to pay attention to this part because it pertains to him. It also pertains to Mark, but we haven't reached that stage with Mark yet. Mark still thinks that he's legit and him not budging and him not renouncing. So now that they are here, let me read it for them again. It was not until November 19, 1998, almost 1 month after her election was certified, that Mrs. Hill took these steps. Took the steps after she was elected and after she was certified as being elected. That's when she decided that she needed to renounce. So let's hear now what the court says, the laws of Australia says about that. By Section 12 of the British Nationality Act of 1981, UK, British citizenship ceases upon registration of a declaration of renunciation. Mrs. Hill completed a declaration of renunciation, paid a fee of $135 Australian dollars, and handed over her British passport. You did that already, Matthew? All right, remember to do that now, all right? Mr. Sue's contention was that as Mrs. Hill held her dual citizenship at the time of being chosen as a senator and had not taken the reasonable steps necessary to renounce her British citizenship, she remained a citizen of a foreign power. As his petition involved constitutional questions, it was referred to the High Court pursuant to Section 18 of the Judiciary Act of 1903 for determination by the full court. So that is exactly what probably will happen as well if somebody or when somebody takes Marky G to court to have a decision taken as to whether or not he's as eligible to sit in our parliament as he seems to think that he is. One of the issues that the High Court had to decide in its capacity as a court of disputed returns was whether the United Kingdom was a foreign power for the purposes of Section 44I of the Constitution. Such a question required the court to consider whether the Constitution is a static document or a document which facilitates and reflects the Australia's constitutional evolution towards an independent sovereign nation. So what is happening here? Just like Australia, you recall Australia was a kind of a penal colony. That's what it was. Britain used to send their convicts there in Australia. So Britain, it was like a big prison camp. The whole continent was like a big prison camp. And so it was being controlled from Britain itself. And so over time, as it became a nation and it started to organize as a country, Britain would relinquish its authority over them. In our case, we got full independence in 1962. Well, we got independence in 1962, but we had two elements of the Jamaica in colonial times that still remains, and that is the Queen as the head of state and the Privy Council. And you're going to read what their lordships said about that relationship between Australia, the Privy Council, and the Queen of England, who was a monarch at the time, in 1999. And that now will tell you and tell us what the likely judgment of any future challenge to these dual citizens in Jamaica will entail when the arguments come up as to whether or not Britain is a foreign power to Jamaica, or whether Britain can be considered a foreign power to Jamaica because of the relationship between the Crown and the Privy Council. They went on to say, in the majority, 4 justices of the High Court declared that even though the United Kingdom was not a foreign power in constitutional terms at the time of federation in 1901, Australia, through a series of events of legislative acts, had evolved into an independent and sovereign nation. In other words, just like us since 1962, right? So they go on to say, this means that the United Kingdom now answers the description of a foreign power in section 44I of the Constitution. Sometimes you might hear me refer to it as 44.1, 44I of the Constitution. As a consequence, Heather Hill's election as the first One Nation senator was declared invalid, and a recount was ordered. Now that recount is, I don't think that we have that recount here. What our judges did in the Dabdou Vaz case was to order that the election run over. Apparently in their election laws, you disqualify and then decide that you're disqualified, then the other person who gets the most vote is the one who now will get the seat. Our judge decided not to do it that way here. Now, this decision of the High Court in Australia is of particular interest to us because now they are discussing the judicial relationship between Australia and the Privy Council, right? So it would affect any ruling in Jamaica because we also have a judicial relationship between the Privy Council in the UK, all right? So let's read what they said. With respect to judicial power, the majority concluded that it was not until the enactment of Section 11 of the Australia Acts, which terminated appeals to the Privy Council, that institutions of government of the United Kingdom no longer exercise any judicial power over Australia. Gleeson, Gomo, and Hayne said this was the case even though Section 74 of the Constitution still allows the High Court to issue a certificate permitting an appeal from a decision of the court on a matter concerned with the limits of the constitutional powers of the Commonwealth and those of any state to the Privy Council. The justices relied on an earlier decision of the High Court in Kermani versus Captain Cook Cruises No. 1, in which it was held that the jurisdiction under Section 74 to issue certificates of appeal is now obsolete. So what is that saying? That is saying that Section 11, which really talks about the termination of appeal to the Privy Council, but that was not what made Australia an independent and sovereign power. No, it was when it terminated, when Section 11 terminated, the powers that the institutions of government in the United Kingdom to exercise judicial control over Australia. It was when Section 11 terminated that. That's when they became an independent and sovereign country. They went on to say it was interesting that the justices raised Kermani versus Captain Cook cruises because in that case the court also said that when appeals came before the Privy Council from Australia, it was settled doctrine that the Privy Council was part of the judicial system of Australia and not an institution of the United Kingdom. So what that is saying, the relationship between Australia and the Privy Council, just as it is the relationship between Jamaica, an independent and sovereign state, our relationship with the Privy Council is not a relationship between us and Britain. It is a relationship between us and the Privy Council. That's what this is saying. So whenever there is an appeal to the Privy Council from the High Court in Australia or from the Court of Appeal here in Jamaica, that it's as if the Privy Council is a part of our judicial system. Nothing to do with the United Kingdom and the government of the United Kingdom. It's a relationship between that court and us. That's what this is saying. Therefore, based on Kermani, it could be argued that as far as the exercise of the judicial power is concerned, Australia had completed its evolution prior to the Australia Acts. And in our case, it would have been at independence. Okay, before that, we were a colony and there was no separation between Britain and us before 1962. When 1962 came and we got our political independence, there is now a separation between our government here. We make laws for ourselves. They can't make no law in England pertaining to us. And that now is how we became an independent and sovereign state. So now we come to the last part, and let us read now what this says. One important question remains. Listen to this question because it pertains to us. How can Australia be completely independent and sovereign in relation to the exercise of the executive power if the Queen of the United Kingdom remains at the apex of government in Australia, legally and constitutionally? We could ask that same question. Are we really an independent country when we have the Queen of England as the head of state in Jamaica? That's what this is saying. They're asking the question about it in relation to them in Australia. So we can ask that question in relation to us. So now, when it comes now to the laws and the Constitution, this now is where our relationship with the British Crown, with the King now as head of state, does that mean that we are not independent, or does that mean that we are independent? Let us read what the judges said. The answer is in the divisibility of the crown. That's what the judges said. The answer to that question is the divisibility of the crown. And what does that mean? Since the enactment of the Royal Style and Titles Act 1953, the Queen of the United Kingdom is to be called Her Majesty Queen of Australia when exercising official duties for Australia. And that is also true of Jamaica. So she was always called Her Majesty Queen of Jamaica. You recall that? You recall hearing that, don't it? Right. So in 1953, this would have been the year now after, or maybe the year when she was crowned queen. They changed the way in which she is to be styled, the way she is to be referred to. And she's now not the Queen of the United Kingdom alone, but she's also the Queen of Australia, Queen of Jamaica, Queen of, the various Commonwealth countries that are still operating as under the monarchy system. The others that are not, like Guyana, they are Republic, Trinidad Republic. They don't have the Queen as head of state. They have presidents. All right, so let me continue. So it goes on to say, what this means is that the Australian crown is divisible and separate in constitutional terms to the crown of the United Kingdom. So, King Charles at the moment wears many crowns. He is the King of United Kingdom and Northern Ireland. He's the king of Australia, the king of Jamaica, the king of Cayman. Cayman is a dependent, a territory, and so on, right? And this is what now, this arrangement is what makes the independence complete, while at the same time where the king is head of state. So the king is head of state of Jamaica in his own right, just as he's head of state of Australia. There's no, what you would call it now, there's no unity. I mean, there is no oneness in them. It's divisible. That's what the Australian judges are saying. So relying on the distinction made between the Queen and the Commonwealth, that is the Commonwealth of Nations, in section 122 of the Constitution, the territory's power, Gleeson, Gomo, and Hayne agreed that the Crown was divisible. So they are citing a section in the Constitution, the territory's power, which I think is their law in Australia. And I'm not sure if that is here, but I'm almost sure because the constitutions of all the Commonwealth countries were drawn up the same way. So there you have it. So when it comes to the Privy Council, the two institutions that remains, which is the link between we and the United Kingdom, is not really between we and the government of the United Kingdom. They don't exercise any control or power over Jamaica. The institutions of the Privy Council, the Judicial Committee of the Privy Council, is an arrangement that we have through the king, if I remember how they style it, right? And the king is the king of Jamaica, separate and apart from any arrangement or any kingship over the United Kingdom. So we are an independent country, and just as we are a sovereign state, so is the United Kingdom. And therefore what they are saying is, there is no question about it. Australia, even though they have appealed to the Privy Council, even though they have King Charles as the head of state, Australia is an independent and sovereign country. And therefore the United Kingdom of Great Britain and Northern Ireland is a foreign power. You hear that, Mark? Good. And I hope Bert Samuels heard it. And I hope, which other one of them, talking about it and skipping over that, right? Well, no, it's not their fault because the persons doing the interview didn't ask the question. So they're not going to answer something that they weren't asked unless it's for some clarity in relation to something that they said. That's how they were trained as lawyers. So that now brings us to the end of this video. I want to thank you for joining me and being so patient. I'm going to edit it and bring it down. It's still too long. It's over an hour. So I'm going to edit it. So you're not going to see it being an hour long. But thank you anyway for joining me. Now it's very important because this matter of the Constitution and the leader of the opposition being the president of the People's National Party, we know that the comrades are going to be very concerned when they see the petition or whatever the hell it's going to be that is put before the court to have Mark removed from the parliament because he's there illegally. And that would be our opinion. So they are going to be concerned. So they need to understand the issues. So I would like, if you know any comrade, share it with them. And the Labour Party people need to understand too, because it's going to affect some of their membership. So share it with them as well. And anybody else you know is interested in politics or interested in what is happening, please share it. Because we need to get the message out so that when they hear these things being discussed on the news, in the media, you know, when they hear the lawyers talking, they know what questions to ask. And you must always be aware when you hear a lawyer talking that some of them have political agendas as well, right? Some of them represent clients or they anticipate that they will represent a client, so they're coming out to talk. If that lawyer is not quoting for you the judgment that this court or this judge ruled this or ruled that, be skeptical about what they're telling you. Once they're only telling you about what the law says, but they're not telling you what the decision of the court was in terms of what the law says, then they're trying to pull wool over your eye. So what you do now, you don't know. So you listen to what everybody is saying, and somewhere along the line, you will get the truth that you can piece together and make sense. All right, that's enough of me now. I have taken up too much of your time as it is. Thank you so much for joining me. And until next time, please take good care of yourself and walk good.